Hello. In this clip from our Justia webinar, your bar license is trapped in the 20th century, or is it? Multi-jurisdictional rules and proposed changes. Charity Anastasio and Micah Bookdahl give some tips about how to maximize your license and what to observe when dealing with marketing and advertising for your firm. If you want to see more Justia videos on law practice and legal marketing, be sure to subscribe to our channel.
The other piece here that is really, I think, super important is often the first step is saying, well, can I practice there? But then you need to ask, if I practice there, what set of rules is actually going to be applying to me and when? And this, I think, is one of those steps that we sometimes forget. And so I go through this all the time with immigration lawyers. So I want to make sure that you all know this you know how to do this yourself. So this is really the interaction of the multi-jurisdictional practice rule with choice of laws. And the main things that you're going to ask at the facts first are, where are the lawyers barred that are involved in this? Where did the work occur? The sitting in the seat, is that practicing law? Comes into effect here. Where is the firm? Where is the court? Where are the clients? And where is the dispute is also a good question. And then you sort of take all those together, and then I pull out that rule for whatever jurisdictions are relevant. And really, you have to look at both or multiple jurisdictions sometimes. Most of them say, very close to the model rule, they will say, you're always subject to jurisdiction where you're barred. And you may be subject to the jurisdiction where you're not barred if you offer services, or if you offer services or provide services, legal services in that jurisdiction. And then it says, well, then which one is really going to win out? And that usually comes down to, if a tribunal is involved, it's where the tribunal sits, unless the tribunal says otherwise, which sometimes they do. Like they might be in Washington state, but to say, I believe here Oregon law applies because of X, Y, and Z, which is usually classic choice of laws analysis, which is very close to what that rule is. And then the second part of this rule is if no tribunal is involved, which is, when you think about it, most of what you do with a client. And this ethics opinion by the ABA, formal opinion 504 that I cite down there, they specifically talk about this and say basically everything pre-trial is tribunal not involved, everything pre-trial. Then that means everything else, they say where the action occurred, unless there's a predominant effect elsewhere, and then it's where the predominant effect is. And then they have one little safeguard for you that says, if you reasonably put it where you think the predominant effect is, then you won't be penalized for it, which I always sort of doubt. Because I think you got to do the analysis to get the predominant effect right sometimes, unless it's really, really messy. And some of my immigration cases are. Now, there's a few states that are really interesting in that it's almost like they don't want jurisdiction. New York is one of those where it doesn't have any of that second part of it. They just say you're subject to the jurisdiction where you're barred. And if you're barred in two places, that's what they think of as the choice of law. If you're barred in two places, we'll answer the question of which one. But they say nothing about if you're not barred there at all, which I think is a little scary. And I always used to presume that your discipline counsel would want to apply their own rules, which I still think is kind of true. But I have seen instances where discipline counsel will be elated to apply a set of rules that, even if it's not theirs, benefits them for what their goal is. So don't make assumptions on this. Do the analysis. Know where it is. I like to tell attorneys to put a choice of laws clause in your fee agreement. It's one of the only ways that you can protect yourself. But as that opinion cites, 5.4 opinion, those choice of laws clauses don't always survive a dispute. And so making it really obvious. Actually, what's interesting about Arizona rule on their 5.5 is they even claim jurisdiction in 5.5, not just 8.5, but they specifically say that you have to do informed consent with clients if you're going to be practicing there without a license. And informed consent is a pretty high bar. It means you've had a conversation with them about the proposed course of conduct. You've given them the risks and the available alternatives to it, which is, and then they sign off on it. So that was a lot of information.
I know. We got to move faster.
Anything that I missed?
No, we got to move quicker. We got 15 minutes left.
Yep. So make your license as versatile as possible. Look for states with the UBE. Look for ones that have good terms in their 5.5. I've named a few there. There's other ones. If you want my list, feel free to email me, which my email is on here. I'm always looking at them and adding new ones to the list. Yeah, I have to add Michigan, which you mentioned, Micah. Look for states with reciprocity with the states you're interested in. Those are usually neighbors or ones with similar requirements, but it won't be all of them. Reciprocity is not an easy way. Pick an only federal practice area. I'm a big fan, or in-house counsel. Don't dabble in state law, though, if you're there. And as we mentioned before, identify yourself. And then keep an eye on those rules, because sometimes you have to certify things like specific certifications about malpractice insurance in Oregon or registration requirements in New Jersey. Each state is different, and they change their rules more than you think they do. Okay, this is you, Micah.
So again, my interest in UPL and MJP really revolves around law firms, business development efforts. And, a lot of times, a lot of the things I work on deal with class actions and mass torts, a lot of PI on the ethics side. And so, so what are you looking at? So when you're marketing yourself and you're concerned with UPL, which is often, a lot of people think like their biggest concern in advertising are the advertising regulations. They'll be like, oh, I forgot to put attorney advertising, or I used the word specialist, or, XYZ. That's not really where it comes into play in real life. Where it comes into play in real life are UPL. Okay. That's, and so, so I always sit there and go, okay, like when I look at an ad campaign, or I look at a law firm's website or anything else, I start with, where are you licensed? Okay. So I make the list of licenses. Where do you have an office? So I look at the offices. When we're advertising, which states are we targeting? Especially today where, 95% of the stuff I look at is digital. And so if I'm looking at a Facebook campaign, I want to see the list of what states we're targeting. Because now we're within that, we're within their borders, right? In terms of marketing. And if it's a particular, let's say it's a catastrophic event, where does it take place? And so when you start marketing for people, in that place, do you have a tie in terms of licenses? And so, associating with local counsel is kind of key, but it's not the only thing. You can go to the next slide. Here's one of my favorite activities when I drive up and down I-95 from my house in South Jersey to Philly, is to look at a zillion lawyer billboards.
So many.
Probably half of them don't comply with the rules of professional conduct. So luckily, PA is one of those states that I consider, for better or for worse, one of the looser in terms of enforcement. That's my personal opinion. But so you have this, pond hockey, all legal matters, anytime, anywhere. So do you have a licensed attorney in Iowa, and do you follow all the rules of the State Bar of Iowa? Okay, so maybe you do. Do you really handle all legal matters because you're a workers' comp firm? So it's just a matter of, again, like looking at the messaging. We can go to the next slide. And, and something I've talked about a lot, and it really relates here to aspects of multi-jurisdictional practice, which is what I call the Morgan and Morgan effect. something I wrote about. I think it's in the written materials or it's on the ABA website. And so it's really the impact that Morgan & Morgan has had on lots of law practices, where all of a sudden you're competing against this firm that came out of, to you, it might have come out of nowhere, and has really sort of forced change in the market. And so, a lot of those billboards that I look at come because of, Morgan & Morgan being there. And let me specify, Morgan & Morgan, okay, does have offices, bona fide offices in every state and licensed attorneys in every state. They're not sitting there with some little, semi-bogus disclaimer that, we only practice where we're licensed and we use local counsel, right? Which I do use all the time, that language. But you can't just use that willy-nilly, right? So in the case of, one of the reasons I like to use this billboard, besides the fact that I spent half my life at Citizens Bank Park, is that you see Saltzman-Jaluzzi at the top there in an advertisement. If you're from these parts or you're involved in the PI world, they're probably one of the most prominent firms in PI in the country. They never advertised anywhere up until the last couple of years. You never saw them do anything. And now they're on the radio and they're on TV and they're on the scoreboard. They're there on the top, and you see Morgan & Morgan is there on the bottom. And then you see Jeff Rosenbaum's ad, hitting at John Morgan. And again, it's a reminder of why we need these aspects of flexibility, because we're competing against these national firms that have a lot of money and are coming into the space and really branding themselves well. And so, if we don't allow smaller firms and a lot of practitioners a little bit more leeway and flexibility to practice law outside of a very specific box, it's going to be very hard to survive. You can go to the next slide. Again, so on one side I have, Morgan & Morgan, and on the other side, here's Gordon Reese, which again, like they advertise, and they do, that they have offices in 50 states or attorneys licensed in 50 states. Now, do they make sure they comply with the nuances of the model rules for every one of those 50 states? Unless they changed some things recently, I would say no, okay, because I've looked at the stuff and it's like, okay, well, you don't have this from New York and you don't have this from California or you don't have this from Florida. And so, so it's really the concept of competing with national law firms. And, do you comply beyond having a licensed attorney there in terms of the rules and the regulations? And again, that's where making 5.5 more of a reality is important for the survival of a lot of practitioners. I've had lawyers in certain spaces who have told me that they've gotten, killed, right? Like that they can't compete anymore in certain practices because of the influx of some of these, sort of large branded firms.
Thanks for watching. We hope you enjoyed this video, and if you did enjoy it, please hit the like button and subscribe to our channel for more videos on law practice and legal marketing. See you in our next clip.